This morning on the Ag Issues program, a pleasure as always to bring back to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine.
Well, I appreciate you coming on to the program as always. And this is a post you had yesterday on your blog, and it's interesting. I like how you put this. From the desk and email and phone, ag law style. In other words, even though it's out of the school year, it's still a very busy time, and I'm sure, to say the least, you never have a shortage of topics that come across your desk.
No, actually, Greg, the academic time is the slow season for me. I know my colleagues don't understand that. They have no clue. Usually, most of them. A couple of them do, but most of them have absolutely no clue of the amount of stuff and the variety of stuff that comes through. So the semesters actually tie me down, and I don't travel as much during the spring academic semester. But boy, once that stops, and of course that's tax season too, so that times well and with that. But once tax season ends, once the academic semesters are done and the law school exams are graded, it's just pell-mell, pedal to the floor all the way to Christmas. And so while I do 1 to 2 events a week through the winter months and the academic semester, now we're looking at an average of 2 to 3 per week all the way to Christmas. And I've got 3 this week and then 2 next week and so forth and so on and on and on it goes. And Branson's coming up this week, so I guess it's going to be hot down in Branson, but I'll be inside speaking a couple of days and then beat it right back to Topeka to do a CLE event at the law school on Friday.
All right, let's get to some of the topics, as you mentioned, many that come across your desk. And the first one is in regard to aerial crop dusting.
Yeah, Greg, this has a number of issues that can come up with it, and primarily the big issue that people have, and the questions that I've gotten recently is, what happens if there's drift? I know my neighbor's going to dust later this summer. I've always been worried about drift. There has been some in the past, but I haven't had crops out there that would have mattered. Now I do. What are the liability rules with respect to that? Well, in many states, crop dusting is viewed as what the law calls an ultra-hazardous activity. And what that means from a liability standpoint is the law does not use a negligence-based approach to determine liability. It's a strict liability approach. So if you're crop dusting and the spray drifts over onto a neighbor, burns their crops, their foliage, their trees, their flower beds, in one instance I had that, destroyed flower beds because they got it on the house, then you're going to be responsible for that. Now, related to that is the landowner's concern, the party that hired the crop duster, and that's the way you should do it. If you're the farmer that has the crops that need dusted, and you're going to aerially apply pesticides, then hire it done and leave your hands off of it. Don't control how the duster is going to do the operation. Don't select the chemicals. Don't tell them how to do it. Just hire them for their service. Let them make all of the decisions. A lot of these companies will sell chemicals too, and so they have the expertise in that, and they're a full service type business. Let them do it, because if they make a mistake, you want the problem to be theirs, not yours. And so that's what we call the independent contractor type relationship. You don't want to use an employee. You don't want to do it yourself unless that's your business, because you want the liability to be on somebody else, not on you. And so that's the key point with respect to this. But we have the drift issue, and then, of course, the issue of who's responsible. And what I tell most farmers is make sure it's an independent contractor relationship and get that contract in writing. Those are all of the steps you can take, the major steps you can take to protect yourself.
Another topic of discussion, which I'm sure comes up a lot, has to do with the right of first refusal.
Yeah, a right of first refusal is what allows the holder the right to buy property on the same terms offered to another bona fide purchaser. So if I want to buy a tract of farmland and it's not for sale, what I can do is I can approach the seller. And this might be a key piece. Maybe it adjoins me. Maybe it hasn't been on the market for 4 or 5 decades. I would really like to have that piece to add to my own property. I can approach the owner, the current owner of that property, and maybe they would agree to allow me to have first shot at that if they want to sell it. So it's not a situation where you're forcing the current owner to sell it. You're just saying, hey, don't shut me out. I'd like to have an opportunity to buy that on the same terms that you offer that to another bona fide purchaser. So if you ever get into an agreement with someone, I want the same deal, and I want you to come to me first. And so if they would notify you that they are going to sell that property, then you can choose. Then you have an option. You can choose to buy it on the same terms that's been offered to somebody else, or decline and allow that owner to sell it to somebody else. It just gives you that right. And we often use those in ag land transactions, particularly where we've got a choice piece of land, and particularly where it joins our property, and we'd like to add that piece on.
Roger McEowen, Professor of Agricultural Law and Taxation, is our guest this morning. Roger, one more additional question on the right of first refusal. From a tenant's point of view, looking at it, if the tenant, do they have the right to acquire the land that they're currently leasing?
Yeah, that's a good question, Greg. And that often comes up in ag settings where you have a longstanding tenant and they're farming for someone who maybe doesn't have a farm heir. And so the tenant would like to acquire that property, perhaps before the owner dies or at death. Now, if it's at death, we can do it a different way. But if it's before the owner dies, maybe they want to sell out and move to town as part of their retirement plan. But they just don't have somebody in the family that could farm that land or is even interested in it. So maybe you've got the situation where you have that longstanding tenant that would like to be given a shot to acquire that leased land. And so that's where a right of first refusal would come in that situation. And even related to that, maybe you have certain family members that should be given the chance to buy into the family farming operation. So the right of first refusal is a good option to have in many situations, but it is critical that the property actually be offered to the holder of the right before it is sold to somebody else. If you don't do that, you could get sued for monetary damages. And the other point is, don't do this with just a handshake or an oral agreement. Get this in writing and have it drafted properly. But properly done, a right of first refusal really can be pretty beneficial to a lot of people in agriculture.
Another topic of discussion is leasing farmland. Of course, that is critical for many farmers and farming operations as well. And probably the biggest question in that is, Roger, what's the best way to structure an ag lease from a tax standpoint?
Yeah, that's another major consideration that a lot of people have. Of course, tenants and landlords are often good at understanding the economics of a farm lease and coming up with the best type of lease to fit their situation from a risk management standpoint. But you also need to look when you're structuring a farm lease to make sure that it fits with your overall tax plan. And so for the tenant farmer, of course, the lease income is income from a farming business that's going to get reported on Schedule F. It's going to be subject to self-employment tax because they are the farmer. And because they are the farmer, also, not only do they have farm income that's subject to SE tax, but they're entitled to government payments in accordance with the lease. So if it's a share lease, you're going to share the government payment with the landlord in accordance with the split that's under the lease. If it's a cash lease, then the tenant gets the entire government payment with respect to that. Now, from the landlord's standpoint, there are 3 ways that those payments, that the rental payment could be reported. It could be cash rental income, which would be recorded on Schedule E, not subject to self-employment tax. It might be some sort of a share lease. And here's where we get the distinction between a material participation share lease and a non-material participation share lease. If you are materially participating as a landlord under the lease, in other words, you're making key management decisions and you're bearing risk of production and risk of price change. So if crop prices go up, you're going to get more in your rental payment as the landlord. If crop prices go down, you're going to get less. If yields are better, you're going to get more. If yields are worse, you're going to get less. If it's that type of lease, then you've got income that gets reported on Schedule F, and so it will be subject to self-employment tax. And that has other implications in the tax code, too, in terms of what you can take advantage of as a landlord. If it is a share lease, but you're not sharing, you're not making key management decisions, so you're not really bearing risk of production, risk of price change, you're just getting a share of the crop, then that gets reported on a different form. That's known as 4835, and that income is not subject to self-employment tax. So there's this line we often play with farm landlords in determining what is their best position to be in from a tax standpoint. Do we want to trigger SE tax? Do we not want to trigger SE tax? Do we want to have a cash lease with what we call a notch in it? In other words, is there a bonus payment at the year end? And how does FSA view these things? And again, if you're splitting it out, splitting the rent out under a share arrangement, then you're going to be sharing the government payments too. So risk management is one consideration for drafting or creating the proper type of lease agreement. Then you have all of these associated tax considerations and government payment considerations also. So it requires a lot of thought.
Moving on, another topic of discussion. And this is, of course, lending corporate cash to shareholders of a closely held corporation. That can be definitely an effective way to give the shareholders use of the funds without facing the consequences of a double tax of dividends.
Well, it can if it is a bona fide loan. You have to avoid having it be a constructive dividend. And this is an issue numerous farming operations face. They want to get cash into the hands of shareholders. You may have shareholders that need some funds, and you want to do so without it being a distribution that's going to get taxed twice. And so any advance or a loan to a shareholder has to be a bona fide loan in order to avoid being a constructive dividend that's going to get hit twice with taxes. So you need to treat it as a loan. The loan's going to have, if it is a loan, it's going to have adequate interest. And a lot of times, Greg, we run into this situation in family settings where there's no loan attached because we're family members here. Just take some money out of the corporation. Well, it doesn't work that way in the eyes of the friendly IRS. So if it doesn't have interest attached to it and the IRS prescribed minimum rate of interest, then you got a problem there. It will get taxed as a dividend distribution. And you just simply can't declare that you intend the withdrawal to be a loan. There has to be additional reliable evidence that the transaction is a debt. So if you have unlimited control of the corporation, it's a closely held farming operation, there's going to be greater potential for a disguised dividend if the corporation hasn't paid dividends, despite having money to do so over the years. That's another strike against you. And that is actually going to be the situation with the vast majority of farming operations. They just don't pay dividends. They plow whatever earnings they have back into the corporation and don't pay dividends. So you've got that strike against you to begin with. Then there's the question of whether you recorded the advances on the corporate books and records as loans, and you executed notes with interest charged, and you got a fixed maturity date, and security was given. So you went through all the formalities of an actual loan, and we see that being a problem in many farming situations too. Plus, there's often no attempt to repay the loan, and there needs to be. So the control issue, what it boils down to, Greg, on all these factors, the control issue is the big one for farming and ranching corporations, and the fact that few corporations pay dividends makes it really tough. And you can do it, but it's critical to carefully build up your evidence that supports what you're doing is actually a loan. And that's the key thing, and I've had a couple of those just in the past month, a couple of those questions come up.
And finally, many a times the discussion has focused on the H-2A temporary ag worker program, but coming up later in the month, there are some new Department of Labor final rules that will take effect concerning H-2A.
Yeah, and this has become a bigger issue with farming operations in Kansas, as well as in the Midwest and the Plain States, and pretty much all over now. The shortage of available help and available domestic workers, for whatever reason, there is that shortage that's out there, and so farmers turn to the H-2A program, and under the program, foreign workers are brought into the U.S. to perform temporary or seasonal ag work, to do things such as help with planting and cultivating and harvesting. And often we tend to think of the H-2A worker rule as, that's a California issue, that's a Texas or a Florida issue dealing with produce and different types of crops than we have here. But it's an issue here. A lot of farming operations are short on help, and so they turn to this program. Well, you're right. Starting June 28th, the Department of Labor has a final rule that's going to take effect, and that rule is going to impact the temporary farm worker program. And what they're trying to do here is increase wage transparency and clarify when an employee can be terminated for cause and prevent employer retaliation against the temporary seasonal ag workers. So the key points on this, Greg, is that farming operations that are in the H-2A program are going to face new restrictions on their ability to terminate workers. There's a very elaborate process that they're going to have to go through if they want to terminate somebody. It's going to be difficult. And that workers that are employed under the program have the right to get paid for 3/4 of the hours offered in their contract, even if the work ends early. Housing and transportation until they leave, payment for outbound transportation, and if the worker is a U.S. worker, to be contacted for employment in the next year unless they are terminated for cause. And then it's going to become much more difficult to terminate somebody for cause. And then if you're transporting these workers, you've got to, if they're in vehicles that are equipped with seat belts, then you have to retain, as the employer, retain and maintain those belts in good working order, and they can't be in a vehicle unless each worker is wearing a seat belt. So more onerous rules are going to take place later in June. Now, the other quirk here is that only applications for the H-2A employer certification submitted to the Department of Labor on or after August 29 are going to be subject to the new rule. So it takes effect June 28, but if you're submitting your certification on or after August 9, then you're going to be subject to the new rule. So I would expect this is going to get challenged in court. We'll see what happens. But the H-2A worker program is going to be, but employers are going to find it more burdensome here pretty shortly.
Never a dull moment, so to speak?
No, not at all. And hit the road to go to Branson this week to speak for 2 days, and then back to the law school to speak on Friday. So busy week.
If they want to see more, they obviously can go to your blog.
That's right, and I'll send it over to K-State this morning. It'll get posted on the Ag Manager website also.
All right, sounds good. Roger, safe travels, and we'll talk to you here in a couple of weeks.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the Ag Issues program here on 580 WIBW.